When you have a convention movement like term limits, that's a very clear, we're applying for term limits. But when you have something like the Convention of States, where do you draw the line between what is and what is not? And I always have reserved slides for various ideas like this. And this one, where we draw the line between what is authorized by their convention application and what is not. In the top right corner there, you see this is what Convention of States says is the limits to their convention. They can only propose amendments on one of these three subject matters. Impose fiscal restraints, money restraints, spending restraints on the federal government. Limit the power and jurisdiction of the federal government. And limiting the terms of office of federal officials. So I want to ask you, and Tom, I'm going to let you kind of speak for everyone. You can throw it in the chat as well if you want to. I'm going to propose, there are 4 different amendments I'm going to highlight here just to see how well we can draw the line between what is authorized and what is not authorized by this more vague Convention of States application. The first one, Governor Newsom would like this first one here of California, changes, updates, or clarifications to the Second Amendment. Do you think that that would fit within the convention subject matter for a Convention of States? Tom, what's your thought on that one?
No.
I don't see anywhere there that specifically says it. That doesn't sound like limiting the power and jurisdiction of the federal government. I don't know. So, but of course, Governor Newsom, some of you may know, just recently came out in favor of an Article 5 convention for changing the Second Amendment and authorizing gun control and things like that. And so, no, maybe that one's not authorized. So they can't talk about that, the Convention of States convention. What about expanding the Supreme Court? Let's pack the courts. You hear that pack the courts scheme come up every once in a while. Biden wants to pack the courts because we have a conservative leaning court. There's nothing that says in the Constitution we have to have 9 justices, so let's expand it to 15, and he gets to appoint all these 6 more justices and flip the balance and so on. Is that within the scope of the convention here?
I don't think so.
And anyone that wants to voice opinions on this in the chat, you can do so as well. What about eliminating the 17th Amendment? Now that's one I support, but again, I don't know. Is that limiting the power and jurisdiction of the federal government? I don't really think so. It's certainly not the other 2.
No.
So yeah, I think probably not there either. Now here's an interesting one. And this is actually a real amendment proposal that's out there. Declaring that federal law can be created by Congress, the president, or federal agencies. They all would now have the power to create law. The president doesn't need to wait for Congress anymore. If he wants to act, this kind of goes back to Obama when he says, I have a pen and a phone, and if Congress isn't going to act. Most of us are familiar with that because Americans knew the Constitution enough to know that's not right. The president doesn't have a pen and phone and he can just create laws by himself. They do it sometimes, even so, and it's totally illegitimate. Article 1, Section 1, Clause 1 of the Constitution says, all lawmaking power granted by the Constitution, paraphrase, is vested in a Congress. Congress is the only one given power to create law. If we have an amendment that refers to federal law being created by Congress, the president, or the administrative agencies, that's a massive expansion of federal power. Now, I'll answer this one for you, Tom, because I asked that one of a Convention of States state director. And they said, absolutely not, totally off limits. That cannot be brought up at our convention, the Convention of States one, because it's not one of those 3. Now, here's the problem. As we're trying to define where do we draw the line between what is and what is not authorized through the Convention of States application? Well, this first one, the Convention of States organization themselves have told us, well, yeah, actually, it's on the agenda. This was asked on their Convention of States official Facebook page. Hey, why don't we include an update to the Second Amendment? Gun advocates wear out the point. It was written when people only had muskets. Why don't we make it read the way we want it to read now? And their answer, this, again, official Convention of States Facebook page says, it's called a clarification clause, and that's very much on the agenda of any number of the study groups being conducted around the country composed of Convention of States project advocates and their state legislators. So the Second Amendment is on the agenda, or I should say chopping block. Governor Newsom would be happy to hear that. So yeah, to me, it sounded like that shouldn't be. And in fact, in other cases, Convention of States has published articles saying the Second Amendment is not on the agenda, except when they say it is. I'm a little confused there. It sounds like they are too. Expansion or elimination of the Supreme Court. Co-founder of Convention of States, Mark Meckler and Michael Ferris founded the Convention of States together. Michael Ferris, after he starts promoting the Convention of States, he starts talking about different ideas of what we could do at this convention if we get this convention to happen. One of which he says is, let's remake the Supreme Court. Let's massively expand the Supreme Court. He wants to create 50, as you see right at the bottom of his little insert there. He wants to have 50 Supreme Court justices modeled after the United Nations Court of Appeals. And so that each state would appoint their own justice. Now, if that is within the scope of the Convention of States application, sorry, Tom.
To limit federal government power?
Yeah.
Yeah.
Yes. If that falls within that, then any court packing scheme qualifies. If the co-founder of Convention of States says this is approved, we can do this, then I guess I'm gonna have to take his word for it. So yeah, Michael Ferris says, yeah, we can do packing courts schemes at this convention. Great. Eliminating the 17th Amendment, Santorum. Rick Santorum's constantly talking about that lately as a lure that, hey, you don't like the 17th Amendment? We need a convention to get rid of it. Really? Okay, I guess that is on the agenda, or at least approved. Now, this last one is shocking to me. We were talking earlier about the Convention of States sponsored simulations of a convention. And back in 2016, they passed an amendment proposal with that language in it. Federal Legislative and Executive Jurisdiction Proposal Number 2. It was designed to give the states power to overturn federal law created by Congress, the president, or the administrative agencies. And in the same breath as trying to give the states more power to overturn federal law, they gave the federal government more power to create law faster than the states could ever overturn them. There's a huge problem there. And it passed, as I have on the screen here, with an 86% majority. Remember what the delegation was like at that convention? 127 people there, 4 were Democrats, all the rest were very conservative-leaning Republicans. I looked up every one of them, by the way, because I wanted to know the political makeup of that convention. 86% majority accidentally did tremendous destruction to the Constitution by saying, yeah, the president can create law. Oops. You see what I'm talking about when someone who's ignorant of the Constitution takes the task of making amendments to the Constitution. Now, what do we learn from all this? We learn that there's a real concern. We really can't define the line between what is and what is not approved for the Convention of States. I'm going to go on to this conclusion here. Either we read their amendment, we read their application very narrowly, or we read it very broadly. If we read it very narrowly, then none of the things on the previous page would be authorized at their convention, and yet they're doing it anyway. Which means that the Convention of States sponsored simulation was a runaway convention, and that their leaders are advocating for a runaway convention by promoting all these other things. They're pushing for a runaway convention. On the other hand, if we interpret their convention application broadly, that all of these things are approved, then everything's approved. We're now in that situation where you may have heard the theory that the guaranteed way to eliminate all crime is to legalize everything. I guarantee we'll eliminate all crime in the city. We'll just legalize everything. Well, that's also the guaranteed way to make sure that we don't have a runaway convention. Let's authorize everything. And if we take the broad interpretation of the Convention of States application, the convention can't run away because there's nowhere for it to run away to. Everything's authorized. But either way, whether we take the narrow interpretation and the convention's already running away, or the broad interpretation, everything's authorized, either way, the Convention of States convention will be a completely unlimited convention. Because they have worded it so broadly, and they're beginning to push for things beyond it anyway. And of course, we spent this entire presentation this evening proving that the precedent for a convention is that they can't be limited anyway. That's why I began with that question. Who would support a completely open convention where everything's on the table, the entire Constitution is up for grabs, and the convention would have the power to write their own rules for ratification? Because that's the precedent. And Mark Meckler and other convention promoters know if they were selling it that way, they would not get any states applying for the convention if they promoted it honestly. I just want them to promote it honestly.